Good morning, friends. A very happy Independence Day. Sat Sri Akal, Namaskar, Adab. Today we were all expecting from our Prime Minister that the accession of civil areas would finally take place, but it didn't happen. Never mind, friends. We are on a crusade to fight this draconian law called the OGB or the Old Grant. In continuation, today we will talk of a very important definition in legal terminology. To begin, I will only talk of permissive possession. I remember there is a bungalow owner in AGRA Cantonment who was my vice president or the vice president, I don't remember. Now we are in love with each other. He doesn't talk to me at all, because people like Jawaharlal Nehru and others used to visit his house. You know, he used to always talk of, Mr. Das, we've been in these bungalows for 100, 200 years. So we should not be thrown out. We are in possession, we are in this, So this is actually called permissive possession. Apart from our civil procedure, even the Portuguese Civil Procedure, there has been a Supreme Court judgment in 1976. And the present incumbent Chief Justice was a lawyer in this case and has very clearly said that even if you are in permissive possession, it is not sufficient to prescribe title to owners of the land. So it finishes. But we people want to live in our own fancy by giving some kind of statements after being in these cantonments for 70 years or 60 years, or reached a superannuation age like this bungalow owner from Agra. So friends, please desist from yourself. We are not in permissive possession. Okay. So I will just talk of this grant. So what is this old grant, which can be even further in some cases taken on too? Now we'll talk of some cases in a very factual position, and I'll be reading these, which I had dug out in my research. Coming to the Rowles versus Manson's case and Lockwood versus Wood. These are cases of 1189 from England. These cases have discussed a grant which is called lost grant. Now how can we put forward our case? That are we a case of old grant, new grant or lost grant? That it is incorrect to suppose that we must assume that in or previously to 1189 the Lord granted to copyholds to his tenants with a reservation of his rights in the terms of alleged custom, as based upon presumption of a grant which has been lost by process of time. I am reading the paragraphs of the court. It is plainly not so in the case of customs, as the old custom of Gavel, King of Brose of England, of having land divisible and various other customs, sufficiently to show some old statements to the contrary are erroneous. Now Gateward's case and Tyson versus Smith at page 421 in the same year. Indeed, the opinion in the House of Salisbury, Marquis versus Gladstone, proceeded on the basis that it is incorrect in the case of a custom to suppose that there has been a grant. So what are they trying to say? Even if there were customs or customaries like we had vasibulars in our country, to have grants, what kind of grants? It is said it is irrelevant of addressing the customs, nor is it necessary for those who allege a custom to show how it arose or might have arisen. The presumption of immemorial origin has been treated as covering a number of difficulties. So even the court at times, looks towards an easier way to find an order against us. the very numerous cases in which the copyhold custom, the vasibulas, has been established, will not be disturbed by proof of the fact that the copyholds in fact did not exist in the manner concerned in 1189. So even in the British judiciary or the law, it was written like this. Another remarkable instance is afforded by the cases where it has been held that customs of entail copyholds has been proved. Now, copyhold he is trying to prove is a kind of a document given in the form of a grant. It is a result not well founded in logic, since there could scarcely have been such a possibility before the statute. The Diest passed in 1285, long after the beginning of the reign of Richard I. We need to see Chalice on Real Properties, 3rd edition. This is a book where on page 27, a judgment quoted of page number 1940-43, AIIER 101, Wolston Limited and Duchy of Lancaster versus Newcastle under Lembrough Council. So these were small petty states in England, and this is how this was being discussed there in a period called 1189 till 1285. So moving back from that period and coming to India, similarly we had grants prior to 1763. Now we have n number of judgments which we have lost in the court cases. I can briefly name them: AIR 1973, Delhi 169, 1998, SCC 456, third 1999-3, SCC 555, 1986 supplement SCC 720, AIR 1980, Bombay 9, AIR 1972, HP 26, 1972-73 SCC 156, 1995 supplementary to SCC 394. You can find these judgments: 1992 SCC 455, 1986 supplementary SCC 720, AIR 1979, Allahabad 170, 201 SCC 208, 1993 SCC 565. So these are all those cases starting from Hardarshan Desai to Purushottam Das Tandon, which we have lost. So there is one another authority which the judge considered to be inconsistent with Miss Cameron's argument, although inconclusive. So Gardner versus Hodson's, Kingston's Brewery Company Limited 1903, AC 229. In that case, the plaintiff claimed under section 2 of 1832 Act that she and her predecessors in title had for more than 40 years been entitled to use as of right a way through a yard. So this is leading from her house to a public highway. She acknowledged that she had paid an annual sum of some 15 shillings, but there was no conclusive evidence as to the origin of the consideration of that payment. The defendant now coming is that the government contended that it was for a license fee to use that passage, but there is no evidence of any agreement, oral or written. So now there are two interpretations. Somebody is using a passage for a long time and claims that she had been paying 15 shillings. The other person, defendant, is saying, no, since it was only for the passage, that was the payment done for. The House of Lords held that plaintiff had not discharged the burden on her of establishing that the user had not been in pursuant to a licensee. Lord Lindley said at page 329, a title by prescription can be established by long peaceable open enjoyment only, but in order that it may be so established, the enjoyment must be inconsistent with any other reasonable inference than that it has been as a right of sense above explained. So, what is he trying? It should have been a plain procedure or a accumulation that somebody has been using a passage. But in this case, it was like she was paying something. This, I think, is proper inference to be drawn from the authorities discussed in the quote below. If the enjoyment is equally consistent with the two reasonable inferences, enjoyment as of right is not established, and this, I think, is the real truth in the present case. The enjoyment is equally open to explanation in one of two ways. Now, see, the easement or the license is also questionable, namely by a lost grant of a right of way in consideration of a rent charge to that lady, which was 15 shillings per year, or second part, by a succession of yearly licenses, not perhaps expressed every year, but implied and assumed and paid for. So, these are the two law points which the court is driving out. The significance of this passage is that Lord Lindley was of the opinion that the payment raised an inference of succession of yearly license, not perhaps every year, but implied and assumed and paid for. This is an emphasis finding done by the courts there. So, the lady's claim to enjoyment as a right failed because she was not able to exclude the possibility that it had been by license of the owner. So, now some people, we were reading once, Mr. Deepak and myself, that under section 54 of the Easement Act, that are we to be called ourselves a licensee? Because somewhere the department and the government uses this terminology. So, in my claim 2001 AIIER 565, para 24 and 25 is to be made applicable on this judgment, which was versus Sunderland City Council. So, friends, the subject matter of a presumed lost modern grant must be a right capable of existing as an easement. In other words, a right to do or enjoy something in relation to the presumed grantee's land, the dominant tenement affecting the unfettered use of the presumed grantor's land, the servant tenement. So, this is the finding which the court gives. Either we are purely a government land and we have been subjected to a license and an easement. Either we put forward this kind of a pleading, or we say that yes, this is a case where we've been given a grant or a copyhold and to do something on it, and that grant is lost now. So, it must be a benefit not enjoyed by the owner of the dominant tenement as an essential incident of his ownership of his land, that is to say without the heed for any grant by the owner of this servant tenement. So, very clearly, he is saying we got to admit today that these are government lands. Then only we can move to the subject called lost grant. For there is no need to assume a lost grant as the only explanation for the dominant owner's enjoyment, if that enjoyment explicably as an incident of a later's ownership of his land. It's not very easy to understand this methodology of claiming ourselves as a lost grant other than an old grant. We can put forward that are we a lost grant or are we an old grant? So again, Palmers and others versus Bowman in another case, juries were first told that from users during living memory or even during 20 years, they might presume a lost grant or deed. Next, they were recommended to make such presumption, and lastly, as the final consumption of judicial legislation, it was held that a jury should be told not only that they might, but also they were bound to presume the existence of such lost grants. Although neither judge nor jury nor anyone else had the shadow of a belief that any such instrument had ever really existed. Now here the case of a lost grant is purely on the basis that none of the GJOs is available. So, but in our cases, we have so many grants. So the result of these development was that, leaving aside the cases in which it was possible to show A, the right could have been existed in 1189, or the doctrine of lost modern grant could not be invoked. So the two things cannot be done. The period was given as 20 years was in practice which at that time, which was even in our Land Revenue Act, to establish a prescriptive or customary right. It was not an answer simply to rely upon the improbability of immemorial use or lost modern grant. Chief Justice Cockburn observed the jury was instructed that if there was no evidence absolutely inconsistent with their having been immemorable user or a lost modern grant, they not merely could but should find the prescriptive right establishment. So these emphasis was therefore shifted from the brute fact of the rights or customs having existed in 1189 or there having been a lost grant, both of which were acknowledged to be fictitious. So the customs, the vasibulas was also given a fictitious thought. Even a presumption by the defendants or the government was also given a fictitious, that there was some kind of grant available. And where did it culminate to? It culminated to the fact that 20 years of being in possession or using, the recognition of a prescriptive right or a customary right. It became established that such user had to be in Latin phrase called nec vi niv claim nec precario. Now what does that mean? Not by force, nor stealth, nor the licensee of the owner. So what are we? Are we this? What I just said? So friends, we need to understand all this. So in continuation to the fact what the earlier in 1189 the judge said, we need to even read another case called Mills versus Gloucester Corporation, 1867. Now what does this say? The unifying element in these three vitiating circumstances was that each constituted a reason why it would not have been reasonable to accept the owner to resist the exercise of the right in the first case, because the right should not be acquired by the use of force. In the second, because the owner would not have known of the user. And in the third, because he had consented to the user but for a limited period. So now Dalton versus Henry Agonis and Company, 1881, AIIER Rep 12830, again House of Lords, was able to rationalize the law of prescription as follows. The whole law of prescription and the whole law which governs the presumption of inference of a grant or a covent rest upon acquiescences. The court and the judges have had recourse to various expedients for quitting the possession of person in the exercise of rights which have not been resisted by persons against whom they were or they are exercised. But in all cases, it appears to me that acquiescences and nothing else is the principle upon which these expedients rest. But in our case, we need to understand, we have Government of India, we have the British government, which claims that the grants were given by the Governor General order. So somewhere it is not an A private owner and a B private owner who have been fighting on that the grant between the two has been lost. One is saying I am an old grant, the other one is saying that I am staying here because he was taking 15 shillings from me. So this is the dispute between two private parties, but here it is between the government and a private party. In the case of easements now, the legislature intervened to save the consciousness of judges and juries by the Prescription Act of 1832. Where is this act? We can always dig into it, of which the short title was an act for shortening the time of prescription in certain cases, Section 2 as amended by Section 1 and Section Revision Act of 1890. Provided in its subpara 391, no claim which may be lawfully made at a common law by custom, prescription or grant to any way or other easements when such way or other matters shall have been actually enjoyed by any person claiming right thereto without interruption for the full period of 20 years shall be defeated or destroyed by showing only that such way or other ways matter was first enjoyed at any time prior to such period of 20 years. So, I am claiming what I have been saying, that we have been in old grant prior to 1763, I have been saying. But nevertheless, such claims may be defeated in any other way by which the same is now liable to be defeated. 1999 AIIER, page 385. This is RV Oxfordshire County Council and another ex parte Suminwell Parshes Council. But what is the doctrine of lost modern grant to apply? Mr. Sendham very clearly submitted that it is a fundamental requirement for prescription. There should be ability of the owner of the servant land to interfere with what is done on his land. In another case, with Megury and Wade in the Law of Real Properties, 5th edition, had very clearly on page 872 said the following quotations of the judge. The whole law of prescription rests upon acquiescences. I cannot imagine any case of acquiescences in which there is not shown to be in servant owner. A, he acknowledges, A means has knowledge of the acts done. 2, a power in him to stop the acts or to sue the respect of them. 3, an absentences on his part from the exercise of such power. So these 3 riders were subjected. Let's put it to the government now. The government had the knowledge, but the government says after 1937, we've been asking for admission deeds. Now, did the government prior to 1936 stop the sale deeds? Did it stop the gift deeds? I think no. Did the government abstain itself from exercising such powers? Well, it is true. So this is how we can produce or create pleadings for lost grant. So if we are not an old grant, people can claim that we are a lost grant, but we need to subject ourselves to some head notes of it. So I hope I am making myself more clearer that what is the difference between an old grant, a new grant or a lost grant, which we can either claim. Once again friends, I am requesting everybody to follow me on my YouTube channels, subscribe yourself so that you are uploaded with all the 150-60 YouTubes lying there. Once again I am saying we are old grant. We do not need to jumble ourselves into anything because we were revenue-free grants of 1763-65. We were supposed to be converted into new grants, which the Britishers never did, even after the 1790, 1812 and 1828 and the last law of 1859. So this makes our proprietorship, ownership on these old grants. Thank you. Good day.